to take the blame. I need the enjoyment of having done it.
Another service I offer.
Yeah, that's right. Just another service.
For your children.
Yeah, yeah.
I can really see the little.
My daughter does competitive cheerleading, and I saw this cheer ad, and it said, cheer dad, it said, scan the big barcode on it, and scan the barcode. It's like, I just never thought I'd be an awesome cheer dad, but here I am.
I used to cheer for North Carolina. It's the only way you could get into it.
I was just saying, to take it over the yell readers or something like that.
You had to have any talent. You had to just sit up there with a microphone. And so I got to see, I got to see Al Cinder play Carolina.
Oh, wow.
At least Carolina tried to play Al Cinder in LA.
Are they looking at it right now?
What? Did you see that? I know that.
Look at you. Look at this guy off. Look what you did
The problem was because they were standing high point.
Yeah, but I can't hear them. I need to whisper.
That's the only way you can turn it off.
Until itself, huh?
But you can't turn it off. No, yeah, you can hold it now.
Oh, yeah.
What she should be.
What is it? Is it like change?
I'm still taller. So, yeah, you're thinking back to the days of the old Russians. Oh, she's 4'10". Is it on Miles?
So, my wife. Yeah.
Oh, yeah.
Fall twice and still win by what, 27?
And, I mean, the lack of people. Oh, yeah.
Yeah, that's a C4 or 5.
Yeah, yeah. What
Well, they do.
concussions like that.
He's looking, I did.
Oh.
They're like the circus. When they're showing certain kinds of things, they'll have lots of that's how they have video. I think one of the ways those boys
You might have to get up there and when I asked him once. These guys aren't in fun mode.
No. No. Good afternoon, Chairman.
Good afternoon, sir.
Good afternoon.
Good afternoon, everyone, and welcome to our Delaware Public Service Commission meeting for November 8th, 2018. We have at first the reading of the meeting minutes of October 23rd, 2018. Does any commissioner wish to have any corrections or modifications made to the minutes?
Mr. Chair, I move that the minutes be adopted as submitted.
I second it.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? Any abstentions? The motion carries. Consent agenda? Anybody want to get rid of the consent agenda?
Mr. Chair, I move that we adopt the consent agenda as submitted.
I second it.
Any discussion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? Any abstentions? The motion carries. By the way, we do miss Commissioner Drexler and Commissioner Conaway. They're both well, but have other conflicts. Number one on the regular agenda is in the matter of the adoption of rules and procedures, the Renewable Energy Portfolio Standards Act. I see Ms. Knott's coming forward, and I believe that Mr. Walsh is going to be representing staff.
Thank you, Chairman Winslow, Commissioners. For the Commission's consideration today is the findings, opinion, and order number 9289, which memorializes the Commission's decisions on the pertinent reissues from the June 5th, 2018 hearing. I want to make two notes first, just to clarify any questions. As I saw this on the agenda, it states memorializing the Commission's decision at the June 19th, 2018 Commission meeting. That should have been June 5th. June 19 was when the Commission approved Order 9241, but I will get into that. That's just one clarification. And on the findings, opinion, and order that you have before you, there's one edit in there from what was submitted. Thank you, Mr. Geddes. Yeah. On page 43, subheading D, which is DENREC's position with regard to discretion to declare a freeze, the word position, it was as submitted, positon. Missed the second I.
Can you identify a paragraph or?
It is subheading D, DENREC's position. Position is misspelled. I will thank Ms. Iori for finding that.
Yes, I already should have found it earlier.
There were about 20 proofreads, and that one got by. The chronology of Reg 56 is, of course, in the findings, opinion, and Order 9289. And I'll just refer to Order 9289 for brevity, and I will also not, of course, repeat the long history of how we got here today. It is in the order. It is in the record, public record, and everybody is aware of it. What I will convey, just a couple of pertinent dates and orders that got us to where we are right here. After the oral arguments on June 5th, 2018, the Public Service Commission approved at its June 19th hearing Order 9241, and that directed the Secretary to transmit to the Registrar for publication in the July 2018 Register of Regulations a copy of that Order 9241 and the then proposed, now current, pending today's approval, of the regulations, which were attached as Exhibit B to Order 9241. And it also directed the publication of the Notice of Proposed Rulemaking, which was Exhibit A to that order, and directed that the notice be sent to the registrar for publication on July 1st. It also, in paragraph 5, established a deadline for public written comments of July 31st, 2018. And we are here today in that final stage of this stage, I should say. The Order 9289 memorializes the Commission's reasoning from June 5. It is rather inclusive, I would say, due in part certainly because of the parties' comments and edits, which I greatly appreciate, all which went into making a final here. The chronology is there, the deliberations are there, the reference to the entire record is there, all in line with the requirements of the APA. And of course, this revolved around those three primary issues, which of course was the total cost of retail electricity, the bloom issue, and the discretion issue as to freeze under the regulations. Those are the new final orders, or rules, I'm sorry, are attached as Exhibit A to the order, and the current rules, which went into the July registration, are attached as Exhibit B. The Order 9289, again, I think is covers it from head to toe, the positions, the arguments, and the Commission's decisions. And I would respectfully request that the Commission approve Order 9289. And unless Commissioners or Chairman Winslow has any questions, I will end there. I think the findings, opinion, and order speaks for itself, and I know you've had time to review it, and certainly parties have. And with that, I would just respectfully request approval.
Thank you, Mr. Walsh. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The Public Advocate has reviewed the proposed form of order. We thank staff for circulating it and giving us the opportunity to provide input. I will say that not all of the input I provided was incorporated, but the vast majority of it was, and I do appreciate that.
Thank you, Ms. Iori. Mr. Goodman, are you going to make any comments?
No, Your Honor, we haven't really participated in the rulemaking necessarily, other than to try and help people that had questions about what we do, which we do all the time. So we haven't presented a position in this. Thank you.
Okay, Mr. Goodman. Mr. Tweedy?
We also had the opportunity to review and comment on the draft, and we appreciate that. I think all or virtually all of our comments were included in the procedural history and our position. I think we did want to offer a few brief comments. Andrea Kreiner is here with me, if that would be appropriate.
We'd love to hear from Ms. Kreiner.
Always a joy to speak with you. I just have a couple of very brief comments to offer and will not restate any of our previous comments on this docket. We just felt it was important that we should note that the cost of RPS compliance went down last year, according to Delmarva Power's own RPS compliance report filed in September. And just to also note that DENREC continues to believe that the proposed regulations are based on an erroneous reading of the intent and substance of the statute and urges the Commission not to adopt the regulations as final. Thank you.
Thank you very much. Mr. Stevenson?
Hello and thank you. And I really do want to thank all of the folks that were involved in this docket. I think it was handled very well. I appreciate the commission's position on this and the decisions that you've made. I think it's the right thing to do. I have one question I would like to ask. It's not about the approval, but after the approval, which compliance year do we begin the process of implementing this regulation? We just passed the 2017-18 compliance year in May 31st of this year. If we began the process, we would be making a decision sometime in the first or second quarter of this coming year. If we wait till the next compliance year, we would not be making a decision about a freeze until probably this time next year. But again, thank you all for the way this has gone. I appreciate it.
That was a rhetorical question, correct?
I'm sorry?
That was a rhetorical question. You're not expecting an answer.
I am not expecting an answer today, but I would ask the commission to consider that question after the approval. Which compliance year are we going to use?
Yes, sir. Commissioners, do you have any questions of the parties?
No questions, Mr. Chair.
Does anybody have a motion to make with respect to the
Yeah, I
proposed
move
order
that we
9289?
Adopt order number 8289.
Corrections, Commissioner, I think it's 9289?
Yeah, 8289?
9289.
It's 9.
Oh, 9289.
Yeah. On that basis, I second the motion.
Is there any discussion on the motion to approve proposed order number 9289?
Aye.
Okay, I guess that's a comment that there's no more discussion. All those in favor signify by saying aye.
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 Are there any opposed, any abstentions? The motion carries. Thank you all very much. I suspect we haven't heard the end. Okay, number 2 on the agenda today. Ms. Kreiner, Mr. Noyes, Mr. Tweedy, thank you for coming by. Number 2 is in the matter of the application of Chesapeake Utilities Corporation regarding its acquisition and conversion of propane. We have quite a list of matters to address on this particular item on the agenda, and there's been considerable written documentation filed. So we're going to start with the DPA and staff's motion to dismiss, and having said that there's been a lot of paperwork on this, I would expect that we should be able to keep the comments relatively short and recognize that the commissioners have read the multiple documents involved in the motion to dismiss. Ms. Iori, are you going to lead the charge on this one?
Actually, no. I'm giving the baton to Mr. Gaddis.
Okay.
Does that mean Ms. Iori won't be able to comment on my comments? Just
I don't think I can stop her anyway if she wanted to.
I hate
Mr.
to-
Gaddis, you can lead off, and I'm sure she won't have very much to say after you're done.
And I will try to comply with, Mr. Chairman, your request that we keep this brief. But I would like to just reminisce for one short second. In 5 days, it will be 26 years, 26 years, since Ms. Iori and I argued in front of the Superior Court with regard to this company and our request that the Commission's jurisdiction apply to Eastern Shore Natural Gas. The company opposed that motion and it went up to the Supreme Court. But eventually, Ms. Iori and I were successful in our position that the Commission's jurisdiction extended over to Eastern Shore because it served natural gas to several customers in Delaware. And here we are, almost 26 years later, and Ms. Iori and I, through a joint motion to dismiss, are arguing that the commission's jurisdiction does not extend to propane dealers. I find that rather ironic, but I shall move on to the merits of our positions. All the parties agree that Chesapeake Utilities is a public utility regulated by the commission. All parties agree that Sharp Energy is a propane provider and is not regulated by the commission. Now, in order for, I'll just go to the board for a minute. In order for Chesapeake to prevail against our motion to dismiss, they've articulated three arguments. The first argument, and I put this as a dotted line, this is Sharp, that's Chesapeake, is that their intention on a temporary basis to convert propane into natural gas should be sufficient to convey subject matter jurisdiction. The second argument is that their peaking facilities provide natural gas services to existing Chesapeake natural gas customers. And the third argument is case law, that they cite a California case, a Maryland case, and 2 Virginia cases as reasons why this commission should extend on a temporary basis jurisdiction over Sharp's assets. Now, these two bridges, if you want, have existed for a long time. Chesapeake has been supplying, or Sharp has been supplying through whatever entity, peaking services to Chesapeake for, I think, over 30 years. These cases, of course, come and go, but they are in different jurisdictions. The real difference here, at least from staff and the DPA's point of view, is this, that it's their intent to convert these facilities, and therefore the commission should extend its jurisdiction with regard to that process. Now, dealing with A, the intention, I don't think it's a persuasive argument to suggest that subject matter jurisdiction rests on a company, whether it's a utility or a private company's intention. If you did that, then you would be subject to variations in your jurisdiction, because clearly, as we all know, intentions, even good intentions, may not materialize or, in fact, change over time.
How about if it was a commission order rather than just the intention of the party?
I don't understand your question, sir.
If there was an order from this commission saying that they had to convert, is that to make a difference?
If it was more than just a business decision, yes, I think it would be meaningful, but it's not. Here, all you have is the company's, quote, stated intention to do this. And I don't think that's sufficient to confer subject matter jurisdiction. That would base the jurisdiction on a day-to-day decision by the private company or the utility, and not on the specific mandates of what the commission's jurisdiction is. We have 2 Supreme Court decisions. One, the Eastern Shore decision that went up and down and up, and another decision involving public service water, which clearly state under the applicable statute, sections 102 and 201, what a public utility is and what the commission's jurisdiction is with regard to it. And nowhere, as admitted by Chesapeake, is there any reference to propane or propane dealers or propane service. So the statute clearly is devoid of any reference. And of course, I probably more than anybody remember 1985 decision by the Supreme Court where Justice Horsey, in dealing with the fuel clause, and I was arguing prudency, he in essence said, pull out the statute and show me where the word prudency appears. Obviously, I failed in that test and lost the case. But it's an analogous situation. Propane does not appear in this statute. And I think that pretty much on its face the end of the argument. So with regard to intentions, I don't think that's enough to subject the propane customers to your jurisdiction. The other two arguments have been there. Obviously, the peaking service is something that's supplied to natural gas customers to facilitate their service. And so it's a benefit to them. So it's completely different than the commission now being, determining rates for propane customers. And the third issue are the cases. I think you would agree that this commission and its interpretation of what its jurisdiction is and is not is a localized issue, more though than general principles based on common law and other types of issues. The Maryland case clearly is not relevant. In fact, Columbia Gas argued specifically what staff's position is here, and the commission didn't address it. The California case involved Catalina Island, where the service company had provided gas service, was changing to some kind of propane, but controlled every utility or every utility service on that island. And that was a distinction, I think, with a difference. And the two Virginia cases, it's unclear exactly why they were decided the way they were. In light of the Eastern Shore and the other Supreme Court decisions that are very clear on the commission's jurisdiction and what it is and what it is not, I think those other cases are not relevant. So in sum, we have some, I would say, ingenious, and I mean that in a positive way, arguments by counsel for Chesapeake to try and extend the jurisdiction of the commission along the dotted lines and the other lines. But I don't think that attempt should form the basis for extending the commission's jurisdiction beyond the entities that provide defined public utility service in the state of Delaware. Thank you.
Chairman Winslow, I do have just one
I knew it.
thing to add. I do have just one thing to add, and that is that the commission it was created by the legislature, and its powers are only those that the legislature has given it. And as Mr. Geddes explained, nowhere in the definition of public utility that the legislature implemented does it say that this commission regulates propane. That is nowhere in the definition. And without that, you can't bootstrap the fact that you provide natural gas service and that you might provide natural gas service to future customers. You can't bootstrap that into a conclusion that the commission has jurisdiction over Chesapeake's temporary or not temporary, depending on how long it might take them, sales to future customers. Thank you.
Do you agree with Mr. Geddes where he says that the only thing we have from Chesapeake is their intentions? They say that, quote, sole purpose, end of quote, is to convert it to natural gas, and it would be only a temporary basis. And aren't there underlying legal documents that commit them to that, quote, sole purpose, end of quote?
Well, on a motion to dismiss, you can only consider what is in the application that they filed, and that's all we considered. I would say that based on my knowledge of what homeowners associations can and can't do, homeowners associations cannot bind individual homeowners to any such contract. So you would have to enter into a contract with every one of those individual owners. And it's very possible that not all of those individual owners will want to take natural gas. We don't know. So I would say, yes, I agree with Mr. Geddes that what Chesapeake intends to do is you can't really take that into consideration because you don't know what these future customers, that's all they are, is future potential customers. They are not bound at this point in time to take natural gas service at any time in the future from Chesapeake.
Doesn't Chesapeake presently, as indicated by Mr. Geddes, operate with propane?
Only for peak shaving, and that is something that helps them provide natural gas service to current customers, not potential future customers.
Commissioners, any questions? Thank you very much, Ms. Iway.
I may
So, by definition, in the context of public utility services, there's a difference between customers and ratepayers. Customer has a discretionary decision. A ratepayer basically is covered by a utility with the CPCN.
That is an interesting point, Commissioner Gray, and without having it might also be, I mean, I would agree with your distinction. However, Chesapeake is subject to a tariff, and I am sure that that tariff defines customer. And if you'll give me some time, I'm sure I can find it on my smartphone. But I am pretty sure that it defines a customer as somebody who is currently taking service from the company, not somebody who might take service in the future.
Mr. Quinn?
Mr. Chairman, good afternoon. Brian Quinn. I'm a lawyer with the Venable firm. You may remember my pretty face from a year and a half ago when we were before this esteemed commission.
No, don't recognize you.
Okay. I got a very Irish face, so you may be confused. And in any event, thanks, Mr. Chairman. It's nice to be here. It's always a privilege to be here. I want to thank staff, too, by the way. I wasn't involved in these meetings, but Chesapeake has met with staff and DPA several times before we filed this application. We're not here just willy-nilly trying to test the limits of the commission's jurisdiction for fun. And we just had a difference of opinion on this question, and we agreed we'd be here today, and I really appreciate their time and yours, as always. While it's at the top of my head, I just wanted to talk about Mr. Geddes' citation to the Eastern Shore case, and I think the water case is the De Pasquale case maybe, or it could be another one. But the difference, and I looked at those cases, obviously, and the difference there was those were unregulated entities. They were in the Eastern Shore case, it was a federally regulated interstate gas pipeline, but not a state-regulated utility. But they were unregulated entities attempting to provide natural gas service, which unquestionably is regulated. Here, we have a public utility already, which is undisputedly already a public utility under Delaware law, seeking to provide an unregulated, which we agree, unregulated propane service, but only on a temporary basis as a means to extend its system to new customers. This is what the company is doing currently in Maryland. In 2013, I represented them at the commission. This is where we got the idea. I just wanted to level set a little bit, where they acquired 5 propane systems in Worcester County, and they're in the process of converting those systems to natural gas. Those systems were immediately brought over into the company's rate base, and that's where this idea came from. That and the fact that they're getting contacted, and DPA may be getting contacted too, but by residents of these propane systems who want to want to be converted to natural gas, and that's sort of the reason why we're here. I just wanted to level set a little bit on that. We agree that Delaware law does not apply to. There's no economic regulation of propane providers under Delaware law. We agree with that notion. It's clear the statute doesn't cover it. In fact, we've argued that in the prior intervention appeal. Of course, it doesn't. But what the Maryland case and what make the Maryland and California cases that we cited so important is because in California, the law is exactly the same. The California law explicitly excludes propane providers from economic regulation by the California Public Service Commission, yet the California Commission approved the provision of propane service to those customers on that island, but they could have been located anywhere, but that's not the point. The point is, under the same facts as we have here, the California Commission and the Maryland Commission approved a public utility, an entity that's already a public utility, providing an unregulated service for purposes of maintaining their system and extending their systems. That's exactly what we have here. So let me, and I want to stress 2 critical points, if I may, Mr. Chairman. I don't want to take up very much time. I know you've read the papers. They're undisputed, and that's what distinguishes the service that we're talking about here. Chesapeake's already a public utility, and the propane service they're proposing to provide is only temporary service until these customers can be converted. What is temporary can be worked out in the workings of this case. But for our purposes, and for the purposes of the cases I cited from other states, that's enough for this commission to exercise jurisdiction. What makes the Maryland case so important is because, and I understand, and we admit this in our brief, the Maryland law is different from Delaware law, but the Maryland Commission applied this exact same analysis and came to that conclusion. There, it just so happens the public utility involved did not want to be regulated and was arguing the other way. But nevertheless, that's irrelevant. Nevertheless, the analysis the commission provided was the appropriate one. And what they said was, there's a important distinction, critically important distinction, between an entity that's already a public utility, providing an unregulated service temporarily, and an entity that is not a regulated utility, so providing propane. So that's the important distinction, that you're already a public utility and the service is only temporary. Under those, if you accept those two critically important points, which are undisputed, then we believe the commission maintains the jurisdiction. Mr. Chairman, you're exactly right. To the extent that there's any concerns about what to do after these customers or the rate base is moved over and these customers are being served, further protections can be worked out in a commission order. Again, that could be worked out in the details of the case. So, maybe anticipating one of your questions, now, having said what I said about a public utility providing an unregulated service, we're not arguing that the commission maintains jurisdiction over everything a public utility does simply because it's a public utility. That's not what we're arguing. The service that the utility provides must be consistent with, and we cite this in our brief, we mention it in our brief, it's got to be consistent with or incidental to its regulated service. And by regulated service, I mean the service it provides under the privileges granted to it by the state. And those privileges are a monopoly, commission, CPCN approval. In other words, this service we're seeking to provide is incidental and directly related to the natural gas service it already provides. We're going to provide it through the same pipes and facilities we're using to provide propane. We're going to use those same pipes and facilities to provide natural gas service. In other words, what we're not saying, another example could be, an example going the other way is if Chesapeake wanted to get into tax preparation business, all right? That obviously isn't incidental and related to their natural gas service, which is, and clearly wouldn't be within the commission's jurisdiction. So that's an important point to make too. It's incidental and adjunct to Chesapeake's ability to extend its system and serve new customers. I want to talk briefly about the peak shaving plants. The peak shaving examples that we provide in our brief are conceptually no different than what we're talking about here. Conceptually, from a jurisdictional standpoint, the peak shavers inject propane through the pipes that Chesapeake owns on a temporary basis to serve customers. And that's exactly what we're doing here. And I want to address very briefly, Mr. Chairman, if I could, two criticisms alleged against our peak shaving argument. That the peak shaving, it's argued that these units are permanent. They're not a temporary solution to peak demand, but that misses its point. It's not the facilities or the peak shaving unit themselves that is temporary. Of course they're not temporary. They're permanent facilities. They have a useful life, but it's the propane flowing through those pipes and the peak shavers that's temporary. That's the exact same thing we'll have here. The facilities that are currently serving the propane customers, the underground pipes and facilities, of course they're permanent. They have a useful life. But it's the propane service that's temporary, not the facility themselves. Second, it's suggested that the peak shaving units are only properly under the Commission's jurisdiction because they're necessary adjunct to providing natural gas service. Of course, we agree with that. We agree with this sentiment. But Chesapeake's proposal to provide temporary propane service is equally a necessary adjunct to extending its natural gas system to the affected customers. Again, we're providing this, we're proposing these acquisitions for the sole purpose of converting them. This is an important point I want to make here, too. Once the acquisition is, and this goes to your question, Mr. Chairman, once the acquisition is consummated, let's say the case moves forward, both the CGS and the existing non-CGS customers alike are all going to be customers of the same utility. So for regulatory purposes, the CGS customers will be natural gas customers. They're all going to be customers of the regulated public utility. Once you bring the assets from these CGS systems into a regulated rate base, they can't just be removed willy-nilly. The commission can also put additional protections in the order if necessary in the case that impose additional restrictions or protections to customers who don't convert, and we can handle that question in the case. And again, I know we talked about Maryland, but I think the California case is far more on point than it's being given credit for. Clearly, under California law, propane providers aren't regulated, but the commission asserted jurisdiction over that service. And it asserted jurisdiction over that service for a couple of reasons, because they want to protect those customers from monopoly market power, wanted to make sure there was no illegal cross-subsidization, and also because those customers could one day be converted back to natural gas. That's exactly the situation we have here. And it's actually more than that. The only reason we're buying these systems and moving them over in our rate base is to convert them back to natural gas. At the risk of going on a smidge more, the Virginia tariff sheets we cited for the fact that Virginia doesn't regulate propane, yet those tariff sheets were approved for Washington Gas and Columbia Gas of Virginia that allow for the temporary provision of propane service through underground pipes in Virginia. It's just another example. Granted, the jurisdictional questions of the commission's jurisdiction weren't raised like they were raised specifically and decided in the Maryland and California cases, but it's just another example, and that's why we cited to them. Finally and lastly, I just want to note that no other party has cited to any case holding that the commission has cited to any case holding an opposite to the Maryland and the California cases that we cite. So in other words, there's no cases cited by any party that hold that a public utility, an entity that's already a public utility that's providing temporary propane service, isn't regulated. So that's why we cited those cases. That's why they're so important. Mr. Chairman, I don't know how to proceed. I wanted to address some, and thank you for your indulgence, by the way. I wanted to address some questions or points raised by the propane providers and Mr. Murphy's clients, but I'm not sure if their motion is even before this commission or not. I'm not sure how you wanted to handle it, but I'm happy if I could ramble on for one more minute. I was going to address a couple of the criticisms that are contained in Mr. Murphy's filing, which I have a pending motion to strike to deal with because I didn't know what else to do with it. But that's kind of where I am. But I'll handle it any way you want, obviously. I could practice. I could promise to be very brief, or we.
Well, first of all, we appreciate your presence and we appreciate your input. Yeah. And you've done an excellent job, so that's not even a question. I guess it's just where we go next. But since you're talking, why don't you conclude and make the comments on Mr. Murphy's points?
And I appreciate that. And again, I spoke with Mr. Murphy before. I spoke to him on the phone. Yeah, I didn't know what else to do. I wasn't sure what those public comments were. They're obviously a legal brief, but filed after the deadlines, as I said in my motion. I didn't know what to do with them, but I thought I'd just address a couple points very briefly. The point that Chesapeake has already converted some other propane systems, which we have done, 3 other systems in the past. But that's correct, but Chesapeake didn't attempt to move those propane systems into its rate base until after they were converted. So we weren't breaking the commission's jurisdictional rules. Those systems were converted and then moved over. What's different here is we're asking to move the systems over immediately while we're converting them. So the prior three systems really has no bearing in here. The argument that Chesapeake's jurisdictional argument leads to absurd results because 1 year later Chesapeake could change its mind. That's what your question was, and that's what some other points were raised. Once these systems are included in Chesapeake's rate base, they remain under the Commission's jurisdiction. A utility cannot abandon or discontinue service under Section 203 AC1 without Commission approval. So any other additional protections you would need, once these systems are moved into the rate base, they're part of the utility's regulated rate base. We can't just abandon or discontinue service to these customers without permission. An unregulated propane provider could, and this is the last point I'll make, could choose to convert their system to natural gas. That was something the propane providers raised, and then they could automatically become subject to the Commission's jurisdiction. Again, that's a different question. That's more closer to the Eastern Shore case, because there you'd have an unregulated company providing a regulated service if they chose to do that. So that's more close. So that's a different question than we have here. And it would depend on the facts there. But nevertheless, even if a propane provider chose to convert their system to natural gas tomorrow, they couldn't begin serving any customers until they had a franchise from the local government, if necessary, this commission's approval to exercise that franchise, and possibly a CPCN. So I'm not sure how that example really works. But with that, thank you very much. Sorry to go on so long. I really appreciate the time. Thank you.
Thank you, Mr. Quinn. Do we have a Mr. Robert Hobson here? Indicates that he's participating as a party, Hart's Landing Homeowners Association.
Rob is not here. He had a death in the family.
I'm sorry, he's not here?
He's not here. He had a death in the family.
Okay, thank you, sir. Apparently, he had a death in the family. He's not present. Mr. Murphy.
Thank you, Mr. Chairman. I want to go, first of all, to your question about if the commission were to issue an order in this docket, does that...
Excuse my interruption, please. Can you,
yes.
your name and affiliation for me?
Yes, I'm sorry. I'm sorry, Mr. Commissioner. Francis Murphy of Murphy and Landon. I represent the three associations that have moved to intervene in this matter: the Delaware Association of Alternative Energy Providers, the Mid-Atlantic Propane Gas Association, and the Mid-Atlantic Petroleum Distributors Association. We have moved to intervene. We also filed public comments. And I did want to, I guess maybe I should say at the outset that Mr. Quinn and I have communicated, and I have made a commitment to Mr. Quinn to communicate better with him in the future, assuming we're in the docket or the docket proceeds. I understand he felt compelled to file the motion to strike. I wanted the commission to know that we're on very good terms, and we understand that we have to do our jobs as attorneys. So with that, going right to your question about were the commission to issue an order in this docket, would that confer jurisdiction? And our position is that just like with a court or any deliberative body, the question of jurisdiction is a threshold issue. And that threshold issue must be addressed before an order could be issued asserting jurisdiction over the proceeding. So the commission cannot itself, by issuing an order saying that it's going to assert jurisdiction over these 40-plus propane systems, confer jurisdiction upon itself. So the question has to be answered at the outset as to whether the commission has the authority to do that.
I think everyone agrees to that.
Now, we wanted to point out that that Chesapeake Utilities is fully capable of converting these systems without asking the commission to assert jurisdiction over propane providers over which it has no jurisdiction. They have already, as pointed out in the record, converted 3 of these systems, and so there's nothing preventing Chesapeake from continuing that process as it has done in the past without the commission having to attempt to assert jurisdiction somewhere where it does not. I think it's evident that the peak shaving argument fails because providing the peak shaving by propane is necessary to serve their natural gas customers. Chesapeake made this temporal argument, well, the propane is only flowing at certain times. The weakness in that argument is, of course, exactly what's been said. Those peak shaving facilities have been in operation for 30-plus years. They are permanent. The idea that the jurisdiction of the commission revolves around whether or not propane is flowing through a propane line or not is, it seems to be an absurd, illogical argument, at least to us. It's a necessary adjunct. That's what Chesapeake admits, that providing those peak shaving facilities is a necessary adjunct to providing energy service to their natural gas customers. And this points up this whole issue of, we intend and we will convert 40-plus systems to natural gas. Well, suppose, as Your Honor has suggested, the commission issues some order asserting jurisdiction and the commission puts a time frame on it, 3 years. What if the process is not done in 3 years? Do the propane customers who have had their rates regulated and their systems regulated by the commission suddenly expire? If the people in the neighborhoods decide that they do not want, as has been pointed out, or some of them do not want the natural gas service, the commission's jurisdiction does not ride on the intention of Chesapeake as to what it may do in the future or how the customers may view it. Your jurisdiction is in the statutes. The island case, we discussed that in our public comments, the California Catalina Island case. We submit that that's a special case. It's a sort of a one-of-a-kind case in the country. And it is true that the staff, the DPA, and the commenters that I represent have not come up with contrary cases. I submit that we have not, because there aren't any natural gas providers out there, as a rule, nationwide, trying to do what's been suggested here. We know that the public utility law is very state-specific, and the statutes, in our view, are clear. The commission should not say it can regulate propane customers, propane systems, the rates charged to propane customers, with the idea that, well, this won't necessarily go on forever. Obviously, no one can predict the future of what is going to happen to 40-plus systems, the cost of propane, the cost of natural gas, which has changed tremendously in this country in a relatively short period of time. We cannot predict the future. So to say that the commission should assert jurisdiction now, not knowing what is going to happen in the future, that's opening the door to all kinds of, we think, potentially problematic results. The commission has to decide today, has to decide whether it has jurisdiction as looking at the Delaware statutes, and Chesapeake admits these systems are not subject to regulation. That's why they set up SHARP, and the commission should not assert jurisdiction, we submit, where it does not have it. That's all.
Thank you, Mr. Murphy. Gosh, there's all kinds of people want to make additional comments. Let's do it in the order we did it before. Mr. Geddes?
I only have one comment, and then defer to Ms. Iorio with regard to the California case. Actually, I have two comments. The definition, which Ms. Iorio, of course, in an upward fashion with her smartphone found for us, and it states specifically that it has to be an existing customer. So specifically, it says under revised sheet 28. Revised sheet 28. Stumble and mumble. The term customer is defined as any individual, firm, or organization purchasing natural gas delivery services and gas sales services or transportation and balancing service in any one month. I think that answers Commissioner Gray's question. My point was, I think the distinction between regulated and unregulated in an attempt to push the Eastern Shore decision aside is irrelevant. As you all know, Eastern Shore is a subsidiary of Chesapeake. Sharp Energy is a subsidiary of Chesapeake, and therefore I don't think that distinction has much merit. And if Ms. Iori might be able to articulate the California case and why it is different.
Thank you. I would just note, with respect to tariffs, the Delaware courts have held that tariffs have the same effect as statutes. So for all intents and purposes, and I don't have that case site right now, but having just done research on that for another case that will be presented to a hearing examiner shortly, I've got the case sites if you need them, just not here with me today. Also, with respect to the California statute, Section 216 defines public utility, and Mr. Quinn is right with respect to Section 216A. It does provide a similar definition to the Delaware definition. However, subsection C of California's Public Utility Law, Section 216, provides that when any person or corporation performs any service for or delivers any commodity to any person, private corporation, municipality, blah, 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 that in turn either directly or indirectly immediately delivers that commodity to the public or any portion thereof, that person or corporation is a public utility subject to the jurisdiction, control, and regulation of the Commission and the provisions of this part. We would suggest that that distinguishes the California cases that Mr. Quinn cited from the case at bar here. The Delaware Public Utilities Act does not contain a similar provision. Finally, with respect to the Virginia cases, the fact that jurisdiction was not addressed does, again, there is case law in Delaware that indicates that that is not precedential because, or is not persuasive precedent, because how can the court or this commission make a decision based on something that you don't know why the commission in that case ruled as it did, having not considered whether there was a jurisdictional issue? Thank you.
Thank you, Ms. Iori. Mr. Quinn, speaking for myself, I am not at all concerned or scared about the future of these customers if we were to agree there's jurisdiction. I don't have any question but that the company is competent to handle the transition, and the staff and DPA are competent to come up with orders that will facilitate that in a way that's in the public interest. But we are concerned about whether or not there's jurisdiction, so if we limit your comments as the other parties have done so.
You read my mind, Mr. Chairman. That's exactly what I was going to do. To be clear, Chesapeake's intent and a commission order were not, if I gave that impression in any way, those do not confer commission jurisdiction. It's not it doesn't matter Chesapeake's intent. The commission's order is whatever it is. That doesn't provide the jurisdictional hook. What provides the jurisdictional hook is this is incidental and adjunct to their provision of service to these customers that for regulatory purposes, as soon as they come over, they're natural gas customers. That's exactly what happened in Maryland. It's exactly what happened in California. The intent and a commission order are not what's conferring jurisdiction here. I'll be very clear. What's conferring jurisdiction is we're already a public utility, and this will be incidental and adjunct to our providing service to these customers. Like I said before, once the deal is consummated, CGS, non-CGS customers, they're all customers of the utility, right then and there. So the fact that the peak shavers provide necessary service to natural gas companies, existing natural gas customers, the propane here is going to provide necessary service to existing customers of Chesapeake who are on the same level as the natural gas customers while they're being converted. The hook is it's incidental and adjunct to, and it's already being provided. It will be provided by a public utility. That's all I wanted to clarify. I'm, no need to I think, I'm not sure the second section of California law Ms. Iori cited. All I know is the California Commission did not rely on that section or analyze it in the case that I cited. I'd have to look at that closer. Thank you.
Thank you, Mr. Quinn.
Chairman
Commissioners,
Winslow.
Ms. Iori?
I'm sorry.
Ms.
May I
Iori.
read you the definition of public utility from the Delaware code as opposed to some other state's code?
Do you mean the one that you cited in your opening brief?
Well,
Is that the one?
The reason that I say that is because nowhere in that definition does it cover services or products that are incidental to a public utilities operations.
Well,
It is only, it is,
I think we know the issue. Can they, do we have the
Well-
jurisdiction to let them do a temporary pass-through to natural gas?
Well,
And that's the issue, right?
it is,
Yes,
but
sir.
I
And you're
did
saying
not,
that, you're saying no, and they're saying yes.
right, but I did not want it to go unsaid that, because I didn't want you to buy the argument that incidental services are covered, because they are not.
No, it's certainly nowhere in the language. I would
It is
concede
nowhere in
that.
the language.
I would concede that. I'm sure they would as well.
Yep.
Commissioners, any questions of any of the parties at this point in time? Does anybody have any thoughts they'd like to express?
I have a few questions, Mr. Chair. I have 4 questions, actually. And I'll direct them to Mr. Quinn, but if there are others who can weigh in, that'd be great. When will all the customers have to take gas from Chesapeake? When?
When, you're assuming the case goes forward, and when will these customers need to be converted by?
What I'm asking is, I assume there's a transaction envisioned. You're making an acquisition.
Yep.
My question is, in the acquisition, as you project these customers coming over to Chesapeake, the question is, when will all the customers have to take gas from Chesapeake?
Thanks, Commissioner. That is an answer we purposefully left open as part of the application, if my understanding is correct. Like I said in my presentation, what's temporary, it can be is something that can be worked out in the workings of the case. I wasn't involved in the meetings with staff and DPA beforehand, but I know that was the thought that went behind leaving that somewhat open.
Do you have a projection? Is it months,
Yeah,
years,
years.
decades?
Years, depending on how many cases the commission orders can be brought over. For example, the Virginia tariffs allow for 26 months or 28 months. The California case didn't put any time limit on that. The Maryland case did impose a 2-year time limit on the conversion process.
Okay, so if the systems are moved to rate base before all customers are converted, then the costs are not necessarily distributed equitably, are they?
Well, that's the whole point of the case, but yeah, once they come over into rate base, again, the value of that is something that will be worked out in the case. We asked for an accounting order as part of this application, and that accounting order is to determine at what value those assets will be transferred into the company's rate base.
So you're on the valuation side of the ledger now.
Yep.
I'm on the distributed cost to the ratepayer side of the ledger. So the question is, while you're making the transition, will the cost necessarily be distributed equitably amongst ratepayers?
They will be distributed according to the current rate structure of the utility. Which, again, that was something that was left open in the application, but on purpose, because that was this application, a similar application has been filed before, and Ms. Iori knows more about that than I do. I wasn't involved in that a couple years ago. And some of the stuff that you're asking, Commissioner Gray, I think may have been discussed or part of sort of what was trying to be decided in that prior case, which has now been withdrawn pending this one. So that is to be determined, but obviously rate design and cost allocation principles are going to apply that's something that would be worked out in the case, but that's something, this would be a public utility, fully regulated asset when it comes over, and all those principles would
Okay,
apply.
so if we're concerned about ratepayers and being just, reasonable, and in the public interest, there's a substantial amount of information for making an informed decision around the rate impacts, right?
Yeah.
Okay. Two more questions. If you were converting firewood customers, would you request jurisdiction from this commission during that transition?
That's a different kettle of fish, Mr. Chairman, or Commissioner Gray. What makes this a particularly attractive proposition is it's exactly what the company's doing in Maryland. These are underground piped distribution systems that can be converted easily to natural gas. I'm not sure we would have to, I don't know how those fireplaces or wood-burning folks would ever get connected to Chesapeake's system. This is something that does, contrary to what Mr. Murphy said, it happens in other states. We cited some of the examples in our brief. It happens in Florida. I found several examples. That's how companies extend their systems. They can either
understand.
build it new or
Yeah.
buy existing pipe systems. I don't think the wood system, I just don't know
Okay.
how that would apply.
So one last question.
Sure.
How does approval of this motion affect the planned transition and conversion?
Well, if you approve the motion, the planned transition and conversion as represented in this application no longer applies. So this is a motion to dismiss. If you approve it, I guess we go back to square one. That's our agreement with staff. We would have to come up with a different way or any way at all, whether or not we'd like to revisit this with the commission. If the motion's rejected and we go forward, that transition and all those details we intend would be worked out in the case, in the body of the case.
Thank you very much, Mr. Chair. I would just like to react to what I've heard so far. The main, or one thing that kind of concerns me a little bit is that there's no real detail or proposed information around the rate impacts for either the future customer or the current customer in order for me to feel comfortable making an informed decision that this is the right approach, given all of the other aspects of whether or not we have jurisdiction. So,
Commissioner Gray, I just point out that this is a jurisdictional issue, it's a threshold issue, and the parties weren't expected to have the details of the transaction, to have them here to be able to set it forth with particularity. This is a matter of what our vote is only on jurisdiction. So frankly, a lot of the information that you've asked about is not, it will be the second step, so to speak, if the first step is a ruling against the motion to dismiss.
is there a CPCN filed for propane services anywhere in the state?
Not that I'm aware. Since propane is not regulated service, I don't think the CPCN rule would apply to it.
Any of the commissioners have a motion? Just a little discussion. I'm just going to talk off the top of my head a little bit. This is as far as I'm concerned, this is a very difficult decision. I assume that Chesapeake has done something which is in their best interest, and it was the most efficient and business-like manner to get this issue to us, probably less costly to people. Obviously, the state of Delaware has some policies we've referred to, or you all have referred to in your briefs, vis-a-vis the extension of gas. There is case law out there that would appear to be supportive of Chesapeake's position, none of which I don't believe is something that we have to do other than to consider. I don't think anything forces us as precedent to follow those other out-of-jurisdiction cases. And I'm very reluctantly come to the conclusion that I'm going to agree with the DPA and staff on this particular motion, and I'm going to make a motion that the motion to dismiss be approved.
I second it.
Is there any further discussion on the motion? All those in favor of the motion signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries, and the matter is dismissed, and we send our best wishes to Chesapeake. And Mr. Quinn, I certainly recognize you, and you always do a great job. Thank you very much for
Sure.
being here.
Thank you, Mr. Chairman.
Yeah. Mr.
Appreciate
Murphy,
it.
thank you, sir.
Thanks, everyone.
Thanks to all. Number 3 is in the matter of the application of Delaware Power and Light Company for an increase in natural gas base rates. Mr. Goodman.
Good afternoon, Chair, Commissioners.
Good afternoon, Mr. Goodman.
So that was a very interesting argument and required you to think really hard about contested issues, so I'm going to hopefully give you a pleasant break here. So fortunately, we are before you with a settlement in a rate case. You heard about our settlement and you approved it in the electric case back in, I think, September. And this is a very similar case, just on a smaller scale, because it's our gas company, which is much smaller than the electric company. But we settled on really almost identical terms using the same mechanisms. Started out asking for what was it, Regina, 13 or 12 million dollars? I should know this, but back over a year ago when we filed. And then with all sorts of changes that happened with the Tax Cuts and Jobs Act, we were able to redo all the numbers and eventually reached a settlement with staff and DPA that, if approved by the commission, will result in a $3.5 million rate decrease for our customers. We resolved at the same ROE we did in electric, which is 9.7%. If you approve this settlement, a typical customer who uses 26 CCF, this would be a customer who doesn't necessarily heat their home with gas, would see a monthly decrease of approximately $1.03, or a 2.6% monthly decrease. And for your typical customer who heats their home using natural gas, and we found that to be about 83 CCFs, and only in a winter month. During those heating months, they'd see a bill decrease of $4.36, or 4.6%. And so, I think it was a great result for customers. At the same time, there was one issue in the case that we were not able to resolve. And what was nice about it is that we all sort of agreed that let's not hold up the case. Let's not hold up a rate decrease to customers, which will also come along with several refunds. The way this is being constructed is, obviously, there's a typical refund that you get whenever you put rates into effect subject to refund. So we'll be able to provide that to our customers. But then there's a series of refunds that'll go for 4 and 5 years that are related to I'm not going to try to explain it. It's the taxation called the EDIT. And I'm not even going to try and explain it. But we want to get that back to customers too. So everyone agreed that that is the best way to do it. So we split it into two. So there is a phase 2 that is on a single issue, that is a regulatory asset that you approved in the last case. We'll be bringing that before you sometime in the first quarter, but it will not prevent these significantly reduced rates from going into effect. So I think we're here today in full support of the hearing examiner's recommendation. I know that counsel for all parties here have reviewed it, and Delmarva here is asking you to approve the hearing examiner's recommendation on the settlement, after which we will immediately begin the process of putting the $3.5 million rate reduction into effect for our customers, as well as preparing to do all the refunding that we'll be doing, both one-time refunds and those that will exist for the next 5 to 6 years. Thank you.
Thank you, Mr. Goodman. Mr. Geddes?
Thank you, Mr. Chairman. Staff and Ms. Davis, who is the case manager on this matter, have carefully reviewed all 7 parts of what is listed in this particular docket. I for whatever reason, a 60-page hearing examiner's report was too much for the particular designation. But seriously, we are supportive of the hearing examiner's decision, and we support the order that's before you that would adopt it. As Mr. Goodman said, there's one open issue, but it was deemed appropriate to bring this matter before you so the rate relief could be put in effect more quickly. And staff supports the order 9269. Thank you.
Thank you, Mr. Geddes. Ms. Iori?
Thank you, Chairman Winslow. The public advocate has nothing to add to what has already been said.
Commissioners, any questions about the order?
Mr. Chair, I move that the Commission adopt order number 9269 as submitted.
I second it.
Any discussion? Hearing none, all in favor signify by saying aye. Aye. Are there any opposed? Any abstentions? The motion carries. The Commission's thanks to Mark Lawrence for his report and to the parties for all their fine effort in this matter.
Thank you.
Thank you, sir. Number 4, in the matter of the adoption of regulation governing administration of the electric and natural gas utility distribution system improvement charge, Mr. Goodman.
Thank you again, Chair and Commissioners. This issue relates to a regulatory docket that you opened, Reg Docket number 64, to start the Administrative Procedures Act process of reviewing proposed regulations for the implementation of the Distribution System Improvement Charge, or DSIC, that was enacted for electric and natural gas utilities by the General Assembly and the Governor this past summer at the end of session. It was noticed that there is a provision or a statement within the opening order that caused significant concern to Delmarva, and we filed a motion asking the Commission to amend that opening order to resolve the Administrative Procedures Act issue. And after some discussions with staff and DPA, it was agreed that that should be removed from the opening order. And I really well, I always do, but I respect and really appreciate sort of the cooperation I had directly from your staff on this and the DPA. And so we have placed before you an order, really 2 orders. One is just an order on the motion that just explains that it's resolved and the motion is resolved. And 2, a revised opening order that simply removes the one paragraph that's problematic, does not change anything going forward as far as the timelines or the rules or due dates or anything in that regulatory docket. So we respectfully request that the Commission execute those 2 orders, and we continue moving forward with the rules process in that reg docket.
Thank you, Mr. Goodman. Mr. Geddes.
Mr. Chairman, members of the Commission, staff agrees that paragraph 5 should be removed from the opening order. All this paper eventually just does that. It removes, 3 lines of an order, and we move forward on an amended order. We support it. Thank you.
Thank you, sir. Mrs. Iori.
The DPA has nothing to add.
Commissioners, any questions? May we have a motion, please?
Mr. Chair, I move that the Commission adopt order number 9282 as submitted.
I second it.
Is there any discussion? Hearing none, all in favor signify by saying aye. Aye.
Aye.
Any opposed?
Yeah, aye.
Any abstentions? The motion carries 3-0. Thank you, everyone.
Thank you.
Number 5, in the matter of written notice of potential violation against CUC, and we have, on this one,
Pardon me, Mr. Chair. I'm sorry. It's 2 orders? Yes, okay.
9290 is the
Right.
one.
All right.
There's an
So-
amended opening order and the order for the motion.
you mentioned them both in your comments. We didn't, I guess,
Right.
make it clear that we were adopting both. So is a motion modified? Is that approved with you?
I'll just make a separate motion, Mr.
Okay.
Chair, that the Commission adopt order number 9290 as submitted.
Okay, thank you.
I second it.
Any discussion? All in favor signify by saying aye.
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 Any opposed? Any abstention? The motion carries. Okay, we're with Mr. Willard, I believe, on this matter.
Thank you.
Thank you, Mr. Goodman.
Yeah, Mr. Quinn was here. I guess nobody's here for Chesapeake at this stage. This is a matter of, there was a notice of potential violation sent out to Chesapeake due to a contractor of theirs not doing things properly. And they were told that there would be a penalty imposed. We would suggest a penalty would be imposed, and they had a chance to try to right the situation and agree to a consent agreement if they want to. They said, yes, we do want to. We drafted a consent agreement calling for a $20,000 fine and acknowledgement that they messed up, their contractor made mistakes and were in violation of law. And this order simply asks you to confirm that consent agreement and impose the penalty. And Mr. Platt is here as well, if you have any questions, or if he wants to speak as well.
Chair Winslow, I would like to note that even though their attorney's not here, there are some Chesapeake employees if the commission has any questions on this matter.
Well, if there's someone from Chesapeake who wishes to be heard, they should just come forward and have a seat and make whatever explanation they want. Otherwise, I'm assuming that since it's a consent matter, that they're having you speak on behalf of the agreement. Mr. Platt, is there any explanation needed, or?
There's no explanation, but I would like to note that this had been going on for approximately at least a year that we know of, this contractor doing what he was doing. And the reason for bringing that up is this was not an easy thing to catch by us or by the Chesapeake staff and inspectors. As it turned out, our inspector, the PSC inspector, Chavis Bianco, who's in the room, did find this. And I'd just like to note that it was a very good catch. And had he not caught it, this could have went on for a long time. So I just wanted to point out that this was a very good catch on his part and very diligent.
Thank you, Mr. Platt. Mr. Bianco, where are you? Well, I see you back there. Thank you for your fine work. Commissioners, any questions?
Yeah, I have this question. What I see here in the consent agreement is a monetary fine. Which or what corrective measures with respect to this particular contractor is Chesapeake taking to prevent this from happening again?
That's a question I cannot answer. That would have to be addressed by the Chesapeake staff.
Is this Chesapeake staff arriving? Thank you for coming. Appreciate it.
My name is Chris Redd, Director of Gas Operations for Chesapeake Utilities. We've actually updated our DEMP plan to identify this risk. We've also severed ties with this contractor in particular and increased our inspections on the service installations.
Do you know the location of the other 28 installations, and have you inspected them to understand what was going on?
Yes, so we went through and we evaluated the different longside services and have completed the corrective actions as of last week on the ones that were in question.
Commissioner Gray, I would like to add that in our initial investigation, we considered the fact that there were other contractors possibly doing this same thing. So we had them check installations that were done by other contractors, and I won't say we were 100% thorough, but we took a pretty good sample size, and we feel relatively confident that everything was just being done by this one contractor of theirs.
So I've asked this question in other hearings. What mechanism, clearinghouse, or capability is there to communicate about this contractor so they don't wind up being hired by someone else performing the same inappropriate work?
I mean, again, from our corporation standpoint, we've communicated it internally and through SHARP and everything, but.
Yeah, but I mean, is there a gas association? I mean, is there any kind of a platform that makes this visible to other gas companies?
Not that I'm aware of.
that's something you folks might want to consider.
The only thing is what we're doing right here and making this a public document, so that this contract, because this contractor's name is mentioned in some of these documents. That's all you got.
If it makes you feel any better, Your Honor, when I saw this posted, everything that they posted on the agenda, I printed it off, sent it to our gas group so they can learn from it. So at least in Delaware, you don't have to worry about any of your regulated gas companies not knowing what this contractor did. And so, you know, it was a good learning for at least your regulated utilities.
Not entirely, because the propane companies are still out
Yeah,
there.
so I said regulated utilities.
Well,
I think we just learned that they're not regulated.
Well,
No, but you're right.
They are regulated under our
Safety.
safety
That's right.
rules, so, and there's, you know, a dozen or so of them.
Yeah, but
So they're still out there.
But I get, you know, the industry trade communications and periodicals, and it would seem to me that the industry would benefit from sharing some of the deficiencies of contractors that have worked for them, that have cost them money, that have cost them consent agreements. And, you know, an ounce of prevention in this area, you know, can be a pound of cure.
I think the associations do a good job of talking about, you know, threats and different situations like this. But I mean, you know, to actually focus on a certain contractor in particular, there's nothing in that form.
I think that the American Gas Association is one association that percolates down issues like this. And of course, they have a magazine as well that dwells sometimes on safety. We've got the Public Service Commission, you've got the individual companies, which I believe are, and I say this about Chesapeake, Chesapeake's helping us now with respect to what happened in Massachusetts. They're always working on safety. And there are some liability issues with damning a contractor because of one incident. And so maybe a private company like Chesapeake or Delaware Power and Light, Exelon, may not be willing to go but so far with respect to what occurred in a given situation.
Chair, if I could, I would like to add that, in my opinion, this civil penalty is a relatively small amount. It would have been a lot more had Chesapeake not been as cooperative as they were in bringing this to closure, finding everywhere that the problems occurred and being very forthcoming in information that we asked for. That was definitely a mitigating factor in setting this civil penalty.
And Mr. Gray, you said something about what are you going to do to fix it? And they've already said the corrective action's already been taken, but I would point out the consent agreement not only lists the penalty, but also lists a variety of things that they now have to do to correct it.
Thank you, sir.
Thank you very
Ma'am.
much. Stay diligent.
Number 6 is in the matter of oh no, we just got finished doing that, I apologize.
Mr. Chair?
Yes, sir.
Should we adopt this order,
Yeah.
9292?
Yes, we should, we should.
I move that the commission adopt order number 9292 as submitted.
I second it.
Any discussion? All those in favor signify by saying aye.
Aye.
Anybody opposed, any abstentions, the motion carries. So we're 9293 at this point in time, I guess. That's Mr. Willard again. And number 6, and this involves Sharp Energy Incorporated.
I see someone is here for Sharp Energy. Again, this is another very similar case. It's the very same contractor made some serious errors, and they were caught by our folks. And they were told that, you know, there's going to be some penalties imposed or suggested to the commission, and they had a chance to sit down with us and do a consent agreement. And so we prepared a consent agreement that called for them to admit the violations and pay a penalty of $12,000. And we worked out the consent agreement, they signed it and agreed to it, and now we're simply asking you to confirm order number 9293, which would accept that consent agreement and impose the penalty.
Would you have Mr. Platt advise us as to why the $12,000 was a reasonable fine under the circumstances of this case?
I'm sure he's willing to do that.
As opposed to the 20,000 to Chesapeake, I assume you're referring to.
Yes, sir.
The guidelines we receive from PHMSA talk about setting civil penalties based on many factors. size of the company, and I understand the relationship Sharp to Chesapeake, but looking at Sharp as its own company, it's smaller. But that's only that's a small part of the reason in this case. The bigger part was about a year ago, we had a civil penalty against a couple of other propane companies, and we set the civil penalty at $12,000. They were equally, in my opinion, egregious safety violations. So in trying to keep things fair and recognizing the fact, and this is probably bigger than anything, that we have no say over the regulation of their costs. So and that's something you always got to keep in mind in setting a civil penalty for a propane company. If you set a very high amount, they're just going to go get it from their customers, and we have no ability to stop that. So in trying to keep things fair with the other propane companies and recognizing the fact that we have no jurisdiction over their rates, we set it at $12,000.
Thank you, Mr. Platt. Sir, would you like to give us your name for the record and any comments you'd like with respect to this matter?
My name is Stephen Farkas. I'm the Director of Propane Operations, Sharp Energy. As far as the comments, very similar to Chesapeake Utilities. You mentioned about a network and communicating when there is a rogue contractor or there are issues. That is how this was brought to my attention, was inter-networking with Chesapeake, recognizing there was an issue. Went out, started investigating our systems, talked with Mr. Platt, Mr. Bianco about, we use the same contractor, and upon investigation, we were finding we had some similar instances, smaller scale, but similar instances. So there is a communication that when, at least in the Delmarva area, when something's going wrong, or a contractor is rogue, or there's an issue, there's communication made immediately, even though we're somewhat two separate business units.
Do you consent to the order?
Yes.
Commissioners, any questions?
I have a question for the staff. What happens if they don't pay this $12,000 in 20 days? What happens on 21st day?
Well, there are essentially late fees and interest
Oh, okay.
that gets tacked on to that. And we have had to enforce that, not with these guys, but with other companies that we have assessed civil penalties against in the past. And I hope that they pay within the 20 days, because it is a real pain figuring out, doing the math to figure out how much they owe in addition to 20,000 or 12,000, whatever it is.
No further questions, Mr. Chair, but I'll move that the order number 9293 is adopted as submitted.
I second it.
Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Stephen. Okay, there's nothing on our hearing schedule today. Is there anyone here from the public that wishes to make comment to the Public Service Commission? Mr. Myers? Any comments?
No, but you all missed returns day, so.
Well, it's not over till it's over. Director's comments.
Thank you, Mr. Chairman, Commissioners. I'll be brief. Public comment session in PSC docket 180953 DPNL prepaid billing. That's on November 28th, 2018, 6 p.m. at the Newcastle County office. The next commission is November 29th, 2018, here at 1 p.m. I have no other comments, and considering we won't see you till after Thanksgiving, I wish everybody a very happy Thanksgiving.
Thank you, Raj. Saved everybody. Thank you, everyone. We are adjourned.